Evidence. The trial, the defendant's case, section 4, proof of justification. What's on Libel and Slander for journalists? Libel and Slander. Trial, the defendant's case. Section 4, proof of justification. 35.9, evidence confined to particulars. The evidence that the defendant can lead in support of a plea of justification is governed by the particulars of justification. The ambit of admissible evidence will be defined by the content of these particulars. If he wishes to give evidence of matters not pleaded, he must seek leave to amend to add fresh particulars. Furthermore, the plea of justification must specify the defamatory meanings the defendant seeks to justify, and he will be confined to establishing the truth of that meaning. Sufficiency of the plea of justification, whether incidents relied upon in the particulars are capable of justifying the charge or are admissible as part of the plea of justification, will normally be determined in the interlocutory stages after service of the defense. 35.10, 35.10, exclusion of evidence. Whereas in criminal proceedings, the court has a general discretion to exclude the relevant evidence because of the adverse effect it is judged to have on the fairness of the proceedings. It is doubted that the judge has any similar power under common law in a civil jury action. However, under CPR, the trial judge does have the power to exclude evidence that would otherwise be admissible and may properly do so in support of and subject to the overriding objective of ensuring that cases are dealt with expeditiously and justly. 35.11, Onus and standard of proof. The onus is upon the defendant to prove the truth of the words in their natural and ordinary meaning, whatever the jury find that to be, or in such innuendo meaning contended for by the claimant and accepted by the jury. The plea of justification will succeed if the defendant proves the sting of or substance of the defamatory words is true, or if the words contain two or more distinct charges, the defendant proves some of the charges to be true, and those not so proved do not materially injure the claimant's reputation having regard to the truth of the other charges. The standard of proof is the civil standard on the balance of probabilities, and this is so even where the defamatory words and the plea of justification allege the commission of a criminal offense. However, the gravity of the issue becomes part of the circumstances which the court has to take into consideration in deciding whether or not the burden of proof has been discharged. The more serious the allegation, the more cogent is the evidence required to overcome the unlikelihood of what is alleged and thus to prove it. Repetition rule and level 2 and 3 meanings. Okay. Axiomatic that the truth of a defamatory allegation cannot be proved by evidence that the claimant has been reported or accused of behaving as alleged. Nor would such evidence suffice where the statement complained of is a report or accusation or the existence of a rumor or belief. Let's do that again. It is axiomatic that the truth of a defamatory allegation cannot be proved by evidence that the claimant has been reported or accused of behaving as alleged, nor would such evidence suffice where the statement complained of is a report or accusation or the existence of a rumor or belief. Mr. X said Mr. Y is a thief is not justified by proving that Mr. X said precisely that. The underlying charge that Mr. Y is a thief has to be justified. This is known as the repetition rule. It is, however, now recognized that it is possible to make statements which convey suspicion of discreditable conduct, but do not go so far as meaning actual commission of such conduct, now called a level 2 meaning. Such statements can clearly be defamatory, albeit less serious than a direct allegation of discreditable conduct. What has to be proved by way of justification to what extent the repetition rule applies has been the subject of much judicial discussion. What has emerged is a list of rules or principles extracted from a number of decisions which were approved by the Court of Appeal in Musa King versus Telegraph Group Limited. The rules prohibit the pleading and therefore leading evidence to prove as a primary fact that some person announced, suspected or believed the claimant to be guilty and generally required pleading and therefore leading evidence to prove allegations of fact, lending to show that it was some conduct on the claimant's part that gave rise to the grounds of suspicion. There can be a still lower level meaning lower level of meaning known as a level 3 meaning, where the imputation conveyed is that there are grounds for investigating the claimant's conduct. Whether the repetition rule would still apply to bar proof of this meaning by evidence of allegations having been made which warranted an investigation of the claimant's activities is not as yet clear. Evidence of justification and mitigation if defense not pleaded. 35.13.
Till I get up, time is barely on our side. I don't wanna waste what's left. The storms we chase are leading us, and love is all we'll ever trust. Yeah, no, I don't wanna waste what's left. And on we'll go.
Evidence of justification and mitigation if defense not pleaded. Evidence of justification. Justification and mitigation. It has long been regarded as established law that in the absence of a plea of justification, the defendant cannot, in order to mitigate damages, give evidence of any facts which would tend to prove the truth of the libel. Nor could he achieve that purpose by cross-examination as to such facts, even if he expressly disavows a justification and states that he tenders the evidence merely in mitigation of damages. It is a principle as old as my recollection of Westminster Hall. The matter of justification cannot be given in evidence in an action in order to mitigate damages. Even in mitigation of damages, it is well settled that you cannot go into evidence which, if proved, would constitute a justification. Nor does it appear to me that it makes any difference that the evidence is offered in cross-examination. Moreover, any attempt to give evidence of facts tending to prove the truth or to elicit them by cross-examination of the claimant or his witnesses, when there is no plea of justification on the record, could be cited as a circumstance which the jury would be entitled to take into consideration as a factor aggravating the damages. Some modification of these bare propositions would appear to have been achieved by the decision in Bernstein versus Times newspapers. It was held that even though there is no defense of justification, evidence could still be led in mitigation of damages of facts, which are directly relevant to the contextual background in which a defamatory allegation came to be made, albeit that the evidence consists of facts that in other circumstances might have been the ingredients of the defense of justification. It was emphasized that the defendant has to accept that the publication complained of is not on the facts justified. Thus, if the libel complained of was a report that the claimant in the course of a drunken brawl struck a woman in the face, evidence could be led that the claimant did get involved in a drunken brawl, though he did not strike anyone, as that would be relevant to the contextual background. Evidence in support of unsuccessful plea or justification. Where a defendant who has put forward a defense of justification is unable to prove sufficient facts to establish the defense, he can still rely on such facts as he has proved to reduce the damages, perhaps almost to a vanishing point. Evidence to support a plea of partial justification can be relied upon in mitigation. However, the defendant will be strictly limited to evidence that can truly be said to go to justification and will not be allowed under the guise of justification to lead evidence damaging to the claimant in other respects, which does not in reality go to justification at all. This approach was confirmed in Burstein versus Times newspapers, in which disapproval was expressed of the practice of seeking to put forward a weak case of justification so as to be able to use the facts pleaded in support of it in reduction of damages. This was described as unsatisfactory tactical maneuvering. Unsatisfactory tactical maneuvering, very important. Five point 1.15. Evidence admissible on other issues. So evidence can we end with this one? Evidence admissible on other issues. Evidence admissible on other issues. Evidence which tends to prove some issue. Okay, evidence admissible on other issues. Evidence which tends to prove some issue properly raised in the action is still admissible, notwithstanding the fact that the effect of such evidence may be to prove the truth of a libel to which no justification has been pleaded. In cases where there is a defense of privilege and the defendant wishes to refute an allegation of express malice, he may well want to establish that he honestly believed the statement to be true and to introduce evidence as to the grounds of his belief. He will be permitted to do so. However, the jury would be directed that, as there was no defense of justification, such evidence could not be considered as proving the truth of the defamatory allegation. It would not generally be permissible to prove the truth of the defamatory words as part of the plea of qualified privilege. Okay. Let's try to finish this section. Other defamatory words, 35.16. Other defamatory words. Where the claimant, in order to show malice, has given evidence of other defamatory words published by the defendant, not being mere repetition of the libel or slander charge, the defendant may prove the truth of such other words. Seems like common sense, right? 35.17, convictions. The question whether a claimant or where there is more than one claimant, any of the claimants did or did not commit a criminal offense is relevant to an issue arising in an action. Proof that at the time when that issue falls to be determined, that claimant stands convicted of that offense is conclusive evidence that he committed that offense, and his conviction is admissible accordingly. For the purpose of identifying the facts on which the conviction was based, there are admissible the contents. For the purpose of identifying the facts on which the conviction was based, there are admissible the contents of any document which is admissible as evidence of the conviction, and the contents of the information, complaint, indictment, or charge sheet on which the claimant was convicted. This is without prejudice to the reception of any other admissible evidence for the same purpose. Spent convictions. Evidence of a spent conviction as defined by the Rehabilitation of Offenders Act 1974 is not generally admissible. This does not prevent the defendant in a defamation action from relying on such a conviction in support of a defense of justification or fair comment, provided it is not proved that the publication was made with malice. Okay, so we stop there. Section 5, proof of fair comment. Point.
Yeah.
Comment. Okay, so we continue there. Section 5, proof of fair comment. Okay. Section 5, proof of fair comment. Okay. All right. So we'll end it there. Until next time. Bye for now. Good luck. All the best to all of you.